Hey viewers, I hope we find you well. Welcome to our show, Let's Get Legal. And today we are joined by our senior legal expert, Mr. Lamet Masango. And we're going to be discussing a very, very important and relevant topic in the employment world, unfair dismissal. Welcome to the show, Mr. Masango.
Thank you very much, Mr. Chwe.
All right. I would want to understand that many a times in the employment world, the relationship between the employer and the employee at times gets sour, and the employers tend to dismiss employees unfairly. And what could you define an unfair dismissal as?
Okay. As per Section 186 of the Labor Relations Act, right? An unfair dismissal is an act or conduct by an employer which terminates the employment of an employee without due process or without a valid reason. So then it would not be called procedural fairness and substantive fairness. Maybe to just go a little bit deeper into that. The Labor Relations Act established that an employment relationship is quasi-mutual relationship between employer and employee, which should be governed by fairness. So fairness should be on both parties. It must be fair to the employer, it must be fair to the employee. So when dismissing an employee, there are certain procedures that needs to be done, and there are certain reasons that need to be forwarded. Yes.
All right. Not a problem. If you could explain further, you explained that there's supposed to be procedure and reasons to their dismissal. If you can just give us an example of the two as you classified them.
Okay, so when we're talking about procedural fairness, right, we're looking at what should be done before a person is dismissed. Many people think that if they catch an employee doing something wrong, then it automatically gives them the right to dismiss these people. Yes. But this is actually not the case, because, you see, when you look at Schedule 8 of the Labor Relations Act, it gives the employer the duty to then investigate a matter and then bring charges to the employee, so that the employee is afforded a chance to also bring about their own version of the story. Right? Because sometimes what seems to be wrong might actually have a background which justifies why an employee had to act in a certain manner. So when you issue out the notification for a disciplinary hearing and the charge sheet, you must give them at least 48 hours for them to be able to prepare, depending on the complexity of the issue. And then a disciplinary hearing must be convened as according to the company's policies and procedures. Right? So when a disciplinary hearing is convened, there must be an external chairperson. So an external chairperson is basically somebody who is not from within the company, because the person must be impartial. And it is very hard to be impartial if you're on the payroll of the company. So this is where a lot of people, employers, get it wrong actually, because they will go and take somebody who works from within the company to say, be a chairperson. But how is that person expected to be impartial?
All right. So then the next question becomes, if an employee is dismissed unfairly, what are they supposed to do?
So maybe if I should touch on substantive fairness a little bit, and then I'll answer that question.
Please do.
Substantive fairness just means the reason behind your dismissal. So basically the reason should be a fair and valid reason.
A fair and valid reason.
Yes, because you find that sometimes a boss would want to dismiss somebody because he made advances and he wasn't successful. And he wants to dismiss. That's not a fair and valid reason. Or a boss wants to dismiss because the employee is now going out with the girl that he wants. Or the employee clashed with his wife or girlfriend. or there's just a general dislike. Those are not fair and valid reasons. So you look at issues like theft. You look at issues like not doing your work properly, late coming. Those are fair and valid reasons.
Yeah.
Yes. And sometimes you get to a point whereby an employer and employee are no longer compatible. So a lot of people don't actually understand that it can also lead to dismissal, because compatibility, when you look at it, it is the reason why there is synergy and harmony within the workplace.
Correct.
If an employee and an employer have a falling out,
yeah,
and they are unable to reconcile and find each other,
yeah,
you will find that the employee will constantly be doing something wrong, which is getting to the employer up to a point that they might just say that it is pertinent that they separate,
yeah,
for the sake of the company,
yeah,
and for their own mental well-being.
Okay.
Right. To answer your question, right?
Yeah.
So when a person has been dismissed, right?
Yeah.
You have to look at it through the rubric of procedure and substantive fairness.
All right.
Right?
Yeah.
Before you can act on it. And usually it's advisable for you to approach somebody with legally sound knowledge, so that they can assist you to do a proper case analysis as to whether your case is worth taking up. Because a lot of people are now burdening the forums like the Bargaining Council, the CCMA, with cases that have no merit.
All right.
Yes. They were caught stealing, but they still want to go and take it up at the CCMA.
Yeah.
They know that they were dismissed for something that is valid.
Yeah.
Right. So the law states that you have 30 days.
30 days.
For you to go and refer your matter at the CCMA.
Okay.
But it does not stop there. If for any particular reason you miss the 30 days, you apply for what is called condonation. Okay. So condonation is basically you're saying to the forum, please, I was late because of ABC and I was so many days late.
Yeah.
May I please be pardoned so that you may hear my matter, because my matter has merit. But when you're applying for condonation, they will look at the period of time in which you are late.
In which you're late.
Yes. Okay. And then they will determine whether it is justifiable that you were late for so many days in accordance with your reasoning that you have afforded.
All right.
We've had people who've come with a matter that is 5 years late. And they have attempted to say, no, let's just go. But it is not feasible for a person to say I was 5 years late because I didn't know.
Yeah.
If you're in a coma, yes, that is practically reasonable for you to be 5 years late. So it has to be the degree of lateness,
okay,
and the reasons given. They need to be reasonable.
Okay.
Yes.
All right. So before we wrap up the show, a very important question is, I understand that you've been doing this for very long. Let's say someone is watching, they've really been displeased unfairly. What would you advise them to do?
I would advise them to pick up the phone, drop us an email.
All right.
I think our number is 010-634-0130.
Okay. Email address
assist@sdls.co.za. Get in touch with us. We will help you. Come through for a free consultation where we do the case analysis. We get to see if your case has merit, if your case is something that we can take on. And we work on no win, no fee. So that will then help them be able to do things the right way. And if they don't want our help and they feel that they can do it by themselves, I advise them to just approach either their bargaining council or the CCMA,
all right,
or the dispute resolution center, whichever one applies to them, so that they may be able to find the justice that they seek.
Okay.
Yes.
All right, viewers, that was our senior legal expert, Mr. Lambent Masango, and I hope you had a good time. I hope you learned so much. And Mr. Lambent, thank you so much for joining us on the show. Until we meet again, it's goodbye for now.
Thank you.